Hi, I'm Karen Morgan. I'm a volunteer with AARP Maryland, and I'm here with another one of our conversations with Senior Legal Services. This one deals with evictions and the kinds of issues that people ages 50 and older can deal with. And our guest today is Jordan Brookmeyer. He's an attorney with a law firm in Owings Mills, Maryland, which has a name that is way too long to pronounce. But anyway, he is a graduate of the University of Connecticut School of Law. He worked for Senior Legal Services as an employee, and he worked on landlord tenant issues for 4 years. Then he went to his law firm where he's at now, where he continues to work on landlord tenant issues. And he still finds time to volunteer for Senior Legal Services. So thank you so much, Jordan. And it's great that you're still finding time to volunteer because I know being an attorney keeps you busy.
Yes, it does. And thank you very much for having me. I appreciate it. So it's a
Great.
good opportunity.
Yeah, this is. Now, why don't you tell us something about Senior Legal Services before we get started?
Sure. So Senior Legal Services is a program in Baltimore City that provides pro bono legal services to Baltimore City seniors. It is, I believe, the only legal program that specifically provides that service to seniors in Baltimore City. And they provide everything from estate planning to legal representation and housing matters, really a wide gambit of legal issues. And they're also, I think, a great, even if you're not in Baltimore City, if you call Senior Legal Services, they'll be able to put you in touch with a resource in your county, generally to the extent there is something there. So it's a good doorway to legal services for seniors um, in general.
Yeah, that's great. And I know we at ARP Maryland really appreciate this partnership that we've been able to set up with Senior Legal Services covering these issues. So let's get into it. There are some common issues that that impact aging tenants maybe more than some other age groups. I'm thinking that's the case, but is that the case or?
Um, yeah, so in my experience, there's a few issues that I've seen come up repeatedly with aging tenants. One common thing that I've seen is, aging in place can become a challenge for some people, and they might need assistance. It's always a challenge to recognize when that point is, but um, what sometimes happens is their apartment the condition starts to decline, and the landlord will send them a notice to terminate their lease based on the condition of the apartment. Some leases say specifically independent living is a requirement. This isn't like an assisted living, but even if a lease doesn't say that, most leases will say that maintaining the unit is a requirement. I think probably even if it didn't say, if it's really a mess, you could probably be evicted for that. So that's something I've seen happen, come up multiple times with seniors. And I'd also mention, just as a good advice, often I see a landlord's reluctance to communicate with family members of a senior if they're hospitalized briefly or more long term or whatever the situation might be, if they're unable to communicate with their landlord. So it's a good idea to have a power of attorney in place, because that will give your landlord some assurance that they can communicate with you, they can accept information from this person. And even if it's just limited to not a power of attorney concerning other financial matters, just for your lease, and even if there's no issue, it's sometimes a good idea to have that on the front end in place, just in case it comes up.
Yeah, that's a good idea. And if you're in Baltimore City, Senior Legal Services can help you set up that power of attorney for your lease.
Yeah, yeah, and senior legal service. They're at senior centers in Baltimore City. There's a lot of options of places you can meet to have estate planning done through senior legal services. Um,
Now,
so
what if you're not in Baltimore City and you think, say you have a lower income and you would like to have a power of attorney set up for your lease, where could you go?
So I believe that like Maryland Volunteer Lawyer Services does estate planning documents, and there's certainly all of Maryland. Um, I'm not sure all the other resources that may be available. I know that Senior Legal Services has partnered with other pro bono programs in having like events to do estate planning at a central location that I believe have been for beyond just Baltimore City. But like I said initially, I if I were a senior outside of Baltimore City, low income, looking to have a power of attorney drafted, I probably would give Senior Legal Services a call and see what other programs they would suggest I reach out to.
Okay, that's a great idea. That's
Yeah.
a great idea. So now there are different causes of action that result in what we call an eviction, and an eviction is actually a very complicated series of legal interventions. And the eviction might be the conclusion of that, but there's a lot that happens before you get to that. So before we talk about what happens if you get a notice of eviction, what are the kinds of things that could cause that eviction notice to be placed on your door?
Right. So eviction really is like the remedy, the enforcement of judgment for possession. Is the eviction. So it's the how you get there, like you said, is from a different cause of action. Primarily, as far as landlord tenant situations go, it would be three different causes of action that would lead to an eviction: a failure to pay rent, a tenant holding over, and a breach of lease. And each of those causes of action are different. The notice requirements are different. So, and I think it's important for people to be aware of the type of case that is being brought against them, um, because depending on what type of case it is, the things at issue, it's important to know what's at issue. So
Right.
if what your like defenses or something is totally different, I paid my rent, well, that doesn't mean you didn't breach your lease. So it's important to know where you are. So just to kind of speak generally about those different causes of action, failure to pay rent, like it sounds, is the landlord saying you didn't pay the rent, and the issue is that rent. This is what the judge is going to see. Is it rent? Was proper notice given? There's a new requirement to give a tenant a 10-day notice of intent before filing a failure to pay rent action. Is the landlord licensed as a rental property, which is also a requirement? And if it
Mm-hmm.
needs a lead paint certificate, does it have one? But assuming it has a lead paint certificate, assuming it has the required registration, and the notice was issued, it's really just a question of was the rent paid or was it not paid, and was what the landlord's claiming rent, is it actually rent? Because it can't include utilities and non-rent charges.
Right.
Um, and and if the answer is yeah, it's rent and I didn't pay it, well, there's going to be a judgment for possession. Now, if you didn't pay it because there's conditions with the property,
Mm-hmm.
so the landlord hasn't made repairs, you can raise that as an affirmative defense and file a rent escrow. Um, and another characteristic that's unique to failure to pay rent as opposed to other causes of action is that even if there's a judgment against you for possession on that day where you go to court, you're going to have the right to pay the back rent that the court found was due and owing and stay in the property. So
Right.
as long as prior to the sheriff coming, it's paid, it can be redeemed. But if that happens one, two, three, four times, then the landlord can file with a foreclosure of rights to redeem, meaning even if you pay, if we've been in rent court for the last 12 months too many times, it's a final judgment, and it'll be evicted,
So,
regardless of what you pay.
so let me jump in here then and just ask you, what if you're, say you're 50 and older or older, and maybe your mobility isn't quite what it used to be, and so you're in this apartment, um, and the landlord isn't doing everything that he or she should be doing to maintain the property, and so you sort of start withholding part of your rent payment or maybe all of your rent payment for a month or two to get the landlord's attention. Is that the course of action that you should take, or what should you do to get your landlord to sort of to avoid the whole eviction conversation?
So, the rent escrow, you can file for rent escrow, and rent escrow it can be like an affirmative defense to a failure to pay rent, or it could be, or it could be raised affirmatively. So, if a landlord is not making repairs, a tenant can go ahead and go file a rent escrow.
And how do you do that? What does that, for our audience, but we may not know what that
Yeah,
means.
so it's a form, where you have to give notice to your landlord of the violations first. It's pretty simple though. You tell them the date that you made the landlord aware of the violations and what the violations are, and then what will happen is an inspector from the city or the county, wherever you are, will come do an inspection of the property, and if they find that there are violations, what will happen is you'll go to court, and the court will generally, and there's different things the court can do, but they'll set up an escrow account where you're going to pay your monthly rent into this escrow account controlled by the court until the repairs are made. And then once the repairs are made, the court will disperse the money either to the landlord or to the tenant or some division. It kind of just depends if the repairs were made timely, if they weren't made at all, or the court can also, as part of a rent escrow, can terminate a lease, which sometimes the
Hmm.
tenant just wants a clean getaway, and the landlord's good with that, so they can terminate a lease, and they can also reduce the amount of the monthly rent. Um, they can have you pay a lesser amount into escrow while it's pending.
Okay.
Um, so, I think you probably could just not pay your rent, and then if the landlord files a failure to pay rent, you can raise it as an affirmative defense. But I think I'd probably be more inclined just to file it on the front end, to so the landlord know that's why I'm not paying rent. And
Does
it's
it cost money to do that?
I'm trying off the top of my head. There is, I think, a filing fee. There
Mm.
are, I believe, reduced filing fees, or there might be a waiver for certain people. Um, but I don't recall off the top of my head what the filing fee is for a rent escrow action. Um, but yeah, so that it can be raised those one of two ways. But my general, I'd suggest that you should go ahead and file it as opposed to just stop paying rent.
Okay. So, and you mentioned two other situations where an eviction notice could be issued, breach of lease and the tenant holding over. So let's talk about, you pay all your rent on time, but
Right,
the landlord still wants to evict you. What could be the
right,
problem?
right. So, okay, we can talk about a breach of lease first. Um, so a breach of lease case, your landlord has to show the court they that there's been a breach of the lease that's substantial and warrants an eviction. So something that's really minor, or maybe not really minor, but a court could find that something is, maybe someone violated their lease. Maybe there's like a pet fee or something that they haven't paid, but it's not,
Or they have a pet. How
they
about
have a
that?
pet and they're not supposed to. But, for instance, like if the lease says if no pets allowed unless you pay a pet fee, that kind of shows that there's something short of there's some additional, we can accept some additional money and allow you to have a pet. So eviction shouldn't be the only resolution. So the court wants to see that there's nothing short of eviction that will work in the case. And so for landlords to start this process, they need to send the tenant a notice 30 days before, in advance, like a 30-day termination notice. If it's a violation that presents an imminent threat to life, health, and safety, they can send only a 14-day notice.
I see.
And if the tenant doesn't vacate, they can then go ahead and file their complaint for breach of lease. So they'll have to establish that the proper notice was given, and they have to establish, like we were just saying, that there is a breach, it's substantial, and it warrants an eviction. So that's the breach of lease. And then this is kind of applicable to all the causes of action. So after court, there's an appeal period that the landlord has to wait to see if the tenant's going to file an appeal before they could do anything. It varies depending on which cause of action it was. After that appeal period has passed, then they file what's called a warrant of restitution with the court. And that warrant of restitution, that goes to the sheriff's department, the sheriff's office. And then they call the sheriff's office once they get a letter back from them to schedule the actual eviction date. So there's still a little bit of a process after court. There's that waiting period. And, depending on how busy the sheriff's department is, the eviction will be scheduled. So it could be months out, or it could be sooner. It just depends on their load.
So that brings to mind the question then, how long does a typical eviction action take? Like from the day that you get the notice, what kind of time are we talking? Could it take a year for your case to actually get to a court, or 6 months?
So I think a year, it wouldn't, I don't think a year, it changes a lot depending on which county you're in.
Right.
I couldn't speak to every single county in Maryland, but in my experience, Baltimore City is much, much slower than Baltimore County. So just as an example, I was recently involved in a tenant holding over case that was filed in Baltimore County, that was filed on February 1st. The court scheduled the hearing on February 23rd, and the eviction, I believe, was on April 11th. So it's pretty fast.
Yeah.
Baltimore City, I had, we had a case that was filed in November of last year that was only heard, I think, last month, and we're still, waiting on the sheriff's department. So it's very much, it depends. But I'd say, I think a year, I think it'd be much less than a year, but it could easily be, it could be 6 months maybe, something like that.
Well, you mentioned your tenant holding over case. What does that mean when a tenant holds over?
So
it sounds like a guest, like a guest you didn't want in the first place, who's clearly overstayed their welcome.
Right. Well, so what it is where a landlord has sent you notice that they're terminating your lease or not renewing your lease. Let's say,
yeah,
you have a month-to-month lease, and they send you notice, effective this date, your lease is over and you have to move. Or you have a year lease and you're just getting a notice at the end of your lease term, your lease is up, you have to move. If they send that notice, and they send proper notice, and we'll talk in a second about what that means, proper notice, but assuming they send proper notice and that date passes and you don't move and you're still there, it's at that time that you're now a tenant holding over. You're holding it over after the end of your lease term. And then your landlord can go ahead and file a tenant holding over action with the court. It's not like a breach of lease where they have to establish any kind of like wrong or anything. It's just, was there a lease? Was there a notice that was, effective notice? Is the tenant still there? And if all those answers are yes, then there's going to be a judgment in favor of the landlord. So as far as notice requirements go, it depends on what type of lease you have. It had been for many years that a 30-day notice was required everywhere, but Baltimore City required a 60-day notice.
Mm-hmm.
Now
Right.
the whole state requires a 60-day notice for a tenant holding over action, for a month-to-month lease. For a year lease, it's a 90-day notice, so 90 days in advance of the end of the lease term.
So the law changed as part of this legislative session that just concluded
I
regarding the
don't.
notice.
It's a recent change regarding the notice requirement, and I think it's something, and I don't really I don't follow it closely enough, but I think it's something that for a while has been considered expanding the notice to 60 days, and I think it might be something that sort of came out of the pandemic that was one of these kind of lasting changes that came out.
Mm-hmm. So, are there some other legislative developments that have happened recently, either this session or maybe even last session, that have changed how landlords and tenants operate in Maryland?
Yeah, so yeah, there's been a lot of different changes. The When I was speaking earlier about the failure to pay rent, the notice requirement, the notice of intention to file, is a new thing, a new requirement that didn't exist before. There's also legislation that was recently passed, um, basically saying that if in a failure to pay rent case, a tenant has made an application for rental assistance in good faith, basically will stay in eviction. Um, so that's really limited only to a failure to pay rent, but that's something that um, came out recently from the legislative session. Um, that's what comes to mind right now. But
Okay.
there's been a lot of developments in this area.
Yeah. So yeah, it's interesting just the way that the pandemic and coming out, going back in, coming back out has sort of changed the ways in which people live their lives. And one of the ways may be that people who are 50, ages 50 and older may decide, yeah, being a homeowner, I'm not really feeling that. Maybe I'd rather rent so I can move when I feel like it, or I want to rent from this community and see how I like it for a while before deciding on where to land. So that's one reason why we need to keep in mind what happens when that eviction, if an eviction notice shows up. We just need to have an idea of how to deal with landlords and tenants. And one thing I hear you saying is that if you are a tenant, engage with your landlord to the extent that you feel comfortable doing that. Don't just be like a signature on a piece of paper, but you know,
Yeah, I think that
especially
there's
if problems come up.
yeah, and I mean I think there's a lot to be gained by being communicative with your landlord about whatever their problem is. I've seen landlords, willing to just have a tenant sign a memorandum of understanding in lieu of an eviction, like if something has been going like an ongoing problem, and now the tenant is saying, okay, I've resolved it, I'm going to sign this agreement that if it happens again, X, Y, and Z, then I'll be evicted. So they're often willing to work with a tenant, um, because it'd be a headache for them to find a new tenant, and there's all
Right.
sorts of other problems. So usually if you can address their concern one way or the other, and sometimes it's not, sometimes there's no love lost between the parties, it's not going to happen, But if you have if you're on relatively good terms with your landlord, I think more good comes from speaking with them than just kind of each one party going in parallel.
Running to the courthouse. That's
Yeah,
it.
yeah,
I'm suing. So
yeah. I think that's probably true about many other areas of the law. I think you know, talking to the
yeah,
other side is good. So
that's true. Well, I think we are going to wrap up. Have you been seeing any questions in the chat that you want to, that you
um,
think we should address, Jordan? And in the
so
meantime, I will just mention that there is a banner showing with links for legal resources for people who are facing eviction. Marylandcourts.gov has a section on that, as well as senior legal services and Maryland legal services in the different counties in the state.
so I think we answered. There's one question that we didn't answer, but I think the others we've answered, which is what's the status of the eviction moratorium?
Mm,
And it is over. I mean, courts are backed up from the pandemic, but their evictions are being scheduled. Um, courts are now back open.
mm-hmm.
And I mean, like I said, each county is backed up to different degrees, but they are hearing all of these types of cases, and the sheriff's office is scheduling evictions when there's judgment.
Okay. So
Um,
we are back in business,
back,
unfortunately,
right,
depending on, whether you need to issue an eviction notice or whether you're getting an eviction notice.
right. And the only other thing I think I'd say is that, if you're having an issue with your landlord, you should reach out to, one of these legal service providers as soon as you identify that there's this issue. It's, if you're going to have to fill out an application for legal assistance, there's going to be uh, time constraints, and you might as well get that ball rolling as soon as possible to find out which resources are available, which ones you qualify for, and then once you find the one you qualify for, the ones to get your application in the pipe, and to the extent you can to get things set up before you're in court, so you don't have to go alone.
Right. And of course, the issue of eviction is far more complicated than what we can cover in this broadcast. So we would definitely encourage you to check out resources from the Maryland courts, from senior legal services, from legal aid resources in your community if you happen to be in that situation. So with that, I'm going to say thank you so much, Jordan Brookmeyer,
Thank
for
you.
offering your help and your services, for continuing to volunteer even though you've got a million other things on your plate. It's very helpful, and I hope this conversations really help people who are tenants and maybe having issues or just want to avoid issues to begin with. And a lot of seniors are not seniors, but a lot of people who are ages 50 and older are, making the choice to rent as opposed to being homeowners. So that's why this issue can come up. So thank you. We really appreciate your time.
My pleasure. Thank you for having me.
And that